me start with Gene. Gene, I'd like you to tell the story. I'm very impressed with what I heard. Now I want to see how you did it. There was this general contractor, we won't say boo, but a general contractor that worked for an owner, and the general contractor was smart enough for himself to put a clause together that he's not responsible with the owner for consequential damages. And then if the subcontractors on the job had a pass-through claim, they would benefit by the same clause. So subcontractors should be aware, and suppliers, that there are pass-through clauses that GCs make you sign. Here might be a good one that you would have been benefited from, and it would not have been a one-sided contract, it would have been in your favor, and apparently in Gene's general contractor client's favor. So Gene, tell us the story about what you did and how you helped your clients.
Yeah, so thank you, Hal. I really appreciate everyone taking the time to be here. As Hal said, I'm Jean Thierry. I'm a partner with Manion Stigger in Louisville, Kentucky. Before rejoining Manion Stigger, I was a partner with a national law firm in the number 5 construction group in the country. While I was with the national law firm, I represented primarily structural steel fabricators. So really the experience of a sub getting beaten up is very, very near and dear to my heart. But I'm excited to be here today and kind of hopefully give you guys some tools that may help make the construction industry a little bit easier to swallow. So I'm going to share a screen here. Oh, Hal, it says it needs you to give me the okay.
Okay, let me do that really quick. Hold on.
So I'm specifically going to be talking about damages in construction projects. So basically the end goal of a court case or an arbitration. Okay, awesome, thank you. Is to, usually you do it because you need to recover money. All right, so I believe you guys can see it now. So there's 3 types of damages in construction cases. There's direct, which is the easiest one to understand. It's the cost to repair or complete. So if someone breaches the contract, it's the cost to repair the work or to finish the project, or if you're the contractor, it's what the owner has to pay you because you did repair and complete the project. Consequential is the main point of what I'm going to be speaking about today. So let me do that one last. And then liquidated damages are a negotiated way. So in the event that a contractor causes a delay, which we all know is rare, and that's usually the bad owner's problem there, the owner may suffer monetary damages. Rather than try to prove actual damages, the liquidated damages are a agreed upon amount that, sorry, I'm trying to move my screens here. They're an agreed upon amount that the owner will suffer due to the delay. It's typically a daily amount. You know, I've seen everything from $200 a day to $1,500 a day, but it's actually spelled out in the contracts that this is the amount of liquidated damages. So as long as the LDs are reasonable prediction of damages and not a penalty, most courts will enforce them. Now, the LD provision is both a floor and a ceiling, meaning that there's a minimum amount that will be paid, but it also caps that amount. One instance is I was representing a very specialized utility product supplier in the expansion of a power plant. And that contract with my client had with the general contractor, it had a daily amount for liquidated damages, but once it hit $1 million, the GC could not recover any more for liquidated damages. So the GC actually claimed that they had hit the entire $1 million limit against my client for delays. So that's how it's the floor and the ceiling. And the owner cannot enforce a liquidated damages claim if the owner contributed to a delay. And in that case with the power plant, that's actually what I was able to show, is that the GC contributed to the delay for my client. And so we weren't liable for the liquidated damages. Now, speaking on what we're going to talk today, consequential damages. So these are damages that don't arise directly or immediately from the breach of the contract. So for the owner, that can mean lost profits. For the contractor, that can also mean lost profits. It can also mean the overhead at your home office. An interesting area too is that the more LEED certified projects and other green projects we're seeing people claim sort of green damages. You know, if your building was supposed to meet a specific energy level and it's higher than that, then an owner might try to go against the contractor for the higher energy costs, or if they lose out on tax benefits because it's not built in time and the LEED certifications aren't there. So those are just some examples. of consequential damages and the other damages that you can see in construction cases. So speaking about consequential damages specifically, the parties can agree to mutually waive consequential damages. And what you see on this slide is the mutual waiver of consequential damages that's in the 2017 AIA A201. And the A201 is the general conditions that are incorporated by reference in the AIA documents. You can see something like this waiver in the AGC's consensus docs too. It's, I don't know, I don't necessarily want to say standard, but it comes up a fair amount. Now you'll see in these subsections 1 and 2 that it's kind of a listing of the types of damages that the parties are agreeing to waive, the types of consequential damages. But if you look at this very last sentence here, it says that really this isn't necessarily a mutual waiver, okay? Because the owner can still get liquidated damages through this last sentence. And the whole point of liquidated damages is to capture the owner's consequential damages, or if you're a sub, to capture the GC's consequential damages. Meanwhile, the lower tier contractor is left with no way to recover these types of damages that are in his or her contract, and that they lose out when there's a delay. So what I'm going to talk to you about today, as Hal said, is a case that I had here in Kentucky where I represented a general contractor against an owner in an arbitration under the American Arbitration Association construction rules. Now, the owner had hired my client, a general contractor, to build an expansion to an existing daycare and preschool facility here in Kentucky. The owner and the GC used the AIA form documents. And in that contract, they separated the work into 2 phases. There was the design phase of the project and the construction of the project. My client performed the design work, but was ultimately not selected to construct the project. Unfortunately, my client was also not paid for his work. So we filed the demand for arbitration because that was the selected method of dispute resolution in the contract. We also filed a lien against the project. And as Hal will tell you, I am a big fan of filing a lien claim. Even if that's not ultimately what you have to recover on, it really lights a fire under reluctant owners and reluctant GCs to make sure that you're getting paid. And it just adds, it's just one more arrow in your quiver that you can use to recover your money. So lien claims, bond claims, those are all really helpful tools that you should always be using to the extent you can to really encourage payment and encourage a quick resolution. So in this dispute, the owner responded to our demand for arbitration, asserting a counterclaim for almost 3 times as much as my client was seeking in his arbitration. So I've snipped here the counterclaim damages summary that was filed by opposing counsel, by the owner. And the good thing here was by this point, she had reduced her claim because this was filed just a week or 2 before the actual arbitration hearing. But as you can see, even though her claim has now been reduced, it's made up almost entirely of consequential damages. She's got rent here, added interest on her loan, lost income, depreciation, all of these things that are typically classified as consequential damages. So when I looked at the contract in this case, it was again an AIA form contract. And it's an earlier version than the 2017 that I showed a few slides ago. But so this contract specifically has a consequential damages provision. So at the arbitration hearing, when I cross-examined the owner, what I did was I blew up into a giant hard copy this portion of the contract, because also at one point during the cross-examination, the owner claimed that she was unable to read tiny print. So luckily the arbitration was at my office, so I blew it up to this gigantic poster size and asked her to get out her glasses and read it to me. And then after she read it, and after it says here that the design builder, my client, and the owner waive claims against each other for consequential damages, I asked her how she could possibly be entitled to any of the damages she's claiming when she agreed to this damage, when she agreed to this provision. I mean, it specifically says rental expenses, loss of use, income, profit, financing, pretty much the exact listing that was in her damages summary. Now, of course, her attorney went through the roof when I did this, but I had done the homework on my front end there, and I had specifically selected a great arbitrator who knows construction, and he ultimately enforced the plain terms of the contract, which here awarded the owner nothing. So that's another little tip with your contracts is you want to make sure that to the extent you're using arbitration, you're really using that provision. I'll put into my contracts of I want somebody with at least 7 years of construction law experience. And I'll put things about what we can get in discovery and what we can't, just to try to keep the costs down. But it really behooves you to do your homework with arbitration and really make that method of dispute resolution work for you. Because I don't know if an attorney who wasn't familiar with the AAA documents, if I had gotten that person as an arbitrator, if they would have been as comfortable with enforcing this. And then the cherry on top about this case was that thanks to the provisions that you see on this slide, my client was actually able to get his overhead and profit because he was terminated through no fault of his own. The owner had no basis for terminating him. And so thanks to good contract drafting where he says cost plus overhead and profit, that's what we were able to recover. So that's it. That's my 15.
Okay, great. All right, hold on. Okay, so thank you very much, Jane. That was like great, and it sets a stage, I think, for Bruce now to come up and talk about the killer clauses and how we're going to be able to fight back and get the result that Jane got because she had a really good clause in her favor. Jane, by the way, how did you get that clause? How did your client get that clause in there? I mean, you know.
So he's really, really good at listening to me. He's not 100%. So generally my favorite is that when I actually can get a client to let us completely write their contract documents so that, and I go in and do in-house training so that my client and all their project managers and everybody knows, hey, these are the landmines I put in here. This is the good stuff that will help you. This is how we use it. But he also was really good about, he was very committed to using AAA forms because that's what his owners liked, is they liked the AAA forms. But he listened to me on the extent of just because it's an AIA form doesn't mean that you can take some liberties with the drafting. And you can make sure to include things like waiver of consequential damages. You can make sure to include things like you get your overhead and profit. You can be specific about who is your arbitrator. So it's just a good client that really took what I said to heart.
That's wonderful. And I like how you said when you and I first met, I asked you about mechanic liens. And you remember what you told me?
They're my jam.
Yeah. You got that. I don't know. Maybe I don't know if everybody's from the South. So can you repeat what you said? What did you say?
Sorry. Mechanics liens are my jam. It's something that I really, it's my favorite part of what I do. And actually the first day I talked to Hal, I had 2 going out that day. It is something you'll see on the internet. There's a lot of programs that try to say that they can do a lien for you and do it quickly. And ultimately it's a relatively inexpensive tool that provides you a lot of security and a lot of peace of mind, but it is incredibly technical and detail oriented, and it varies state by state.
Right. As you know, I went through 18 law firms to find you. Okay.
Yes.
And thank God we went through. Lamar was helping me. He can tell you the story too. It was like a day from, it wasn't, the mechanic liens are our jam too, but finding the right local counsel, because I was retired, you know, before we didn't have anything the last couple of months in Louisiana, I mean, in Kentucky. So it's great to have you there. But can you tell us for 1 minute, what kind of liens are available to sub suppliers in, for example, Kentucky? Because I did read the statute. I was looking for the 18 lawyers and I was like flabbergasted. Okay. And thank God, and I'm pretty smart on this stuff, how well you explain that. So what kind of rights do people have in Kentucky? So
Kentucky and Indiana, you can file liens on residential projects. You can file liens on commercial projects. Both states do have a unique recovery option for public projects. So those are projects like state highways, public schools, state universities. In Kentucky, for instance, we have a very weird quirk about the lien has to be what's called attested by the county clerk. And it's a weird, funky process. And essentially it just involves, you really have to have a good relationship with each county's county clerk to get it done correctly. We also have the Kentucky Fairness and construction statute, which helps for recovery of attorney's fees. And it helps block the enforcement of kind of killer clauses, if you will, about giving up your lien rights and what happens when an owner won't pay and can increase your interest rates. And then we have, there's always payment bond claims, which most generally, if it's a public project, there's going to be a payment bond. So it behooves you again to look for it, especially Corps of Engineer projects. It's very easy to get the payment bonds, and that's pretty much a universal thing, that another tool that you can use to help recover.
That's great. You know, it just for your information and for the other panelists in the audience here today, the lien on public funds that Gene did for us was on an elementary school, and you know, you mentioned something, you know, state highways or municipal. In the state of Maine, after you and I were working, you know, we are now involved in a case, and I noticed that they had a right of lien on funds in Maine, but it was limited only to municipal projects, not state projects. However,
interesting.
Yeah, it was interesting because I'm, you know, in my state, which is emulating your state, it's a lien on public funds for state and local, but here it was only for local, not for state. However, when we negotiated with the subcontractor, who probably didn't know better, you know, we were a supplier to a sub, to a GC, we said, we're liening the funds. And that bothered him. So we kept saying that. Hopefully he wouldn't remember, okay, you can't have a lien on funds yet, just a bond claim. So just because you don't have something doesn't mean you can't ask for it, but you got to be a little bit aware of which is legitimate or not. All right, so thank you very much. Great story. Your client's very lucky that you were able to prevail, and you're a great counsel.